Thank you so much for joining us. My name is Jie Huang. I am a senior associate at Scott Legal PC, and I specialize in extraordinary ability petitions. So today we are going to spend some time talking about the visa options available for individuals with extraordinary abilities in their fields. So just a few things, housekeeping details before we get started. Okay. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of non-immigrant and immigrant visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will be continuing these webinars. We are doing a series of webinars, and we are hosting at least 2 webinars a month on different immigration law topics. So please feel free to follow us and check us out for additional webinars that are coming up in the future. At the end of this webinar, we will be sending out a few things to all participants. First, we will be sending out a copy of the PowerPoint that you see on the screen here that will be sent to all participants. We will also be sending you a comprehensive visa guide that you can use as a reference that covers all of the visa categories that we will be talking about today. Finally, we will also send you a link to where you can follow to sign up for additional webinars that are coming up in the future, and also this webinar as it will be recorded. This webinar will also be made available on YouTube, and we encourage you to subscribe to our YouTube channel and hit the notification button as we regularly do upload a variety of immigration law related videos. Finally, we will also send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. For any questions you may have during the presentation, please feel free to add them to the chat box or to the Q&A function, and we will try and get to all questions. So without further delay, let's get started. So let's begin with an overview of what are the extraordinary ability visa categories. Those are visa options available to individuals who have extraordinary ability in their fields. So let's start with the O-1 visa. So the O-1 visa is applicable to individuals active in the sciences, education, business, or athletics. And to qualify for the O-1 visa, you must have received national or international acclaim in your field. And the standard of extraordinary ability is that you must have risen as one of the small percentage who has risen to the very top of their field of endeavor. The O-1B visa is relevant to individuals who are active in the arts, motion picture, or television industry. And the standard for extraordinary ability is a little differently phrased in the O-1B context. So for the arts individuals active in the arts industry, the standard is distinction. And what does distinction mean? It means a high level of achievement, a degree of skill and recognition that is substantially above that is ordinarily encountered in their field, such that the person must be described as someone who is prominent, leading, or well-known in their field. Now, the standard for the motion picture and television industry is phrased a little differently. So extraordinary ability here means that the individual is able to provide evidence showing that he or she has reached a level of acclaim that is substantially above his or her peers. Now then, the third type of extraordinary ability visa category is the EB-1A green card. And the difference between the O-1A, O-1B, and the EB-1A is that the O-1A and O-1B are both non-immigrant visa categories. So you are able to come to the United States temporarily for work, but after your work arrangement is over, you will return to your home country. Now, the EB-1A is a permanent residency option. It is an immigrant petition for someone who is in one of those fields that have extraordinary ability. So this is a green card option, basically. And the advantage of the EB-1A green card category is that an individual with extraordinary ability can self-petition for the green card. And that is an advantage that is not commonly given to employment-based green cards, usually for example, for EB-2 employment-based green card, EB-3 employment-based green cards, you need a U.S. sponsor. You need a U.S. company to sponsor you and to give you a job offer. And plus, in most cases, the U.S. employer needs to go through what is called a labor certification process. It means they need to actually test the labor market and try recruiting for workers and show that there is no one else in the United States who is qualified to do that job before they can offer the job to a foreign national. However, for the EB-1A green card category, you don't need any of that. You don't need a U.S. job offer. You don't need to go through a labor certification. You can self-petition for the green card as an individual, and you can do this completely from abroad as well. And if you use premium processing, you could get an answer on your EB-1A immigration petition within 15 days, 15 calendar days, if you use premium processing. So this is definitely one of the fastest ways you could achieve a green card in the United States. So another thing to note is that the EB-1A green card is one category for all fields. So you would see that the O-1A visa and O-1B visa are separate categories relating to distinct fields. But for the EB-1A, it's just one category for all of the fields. And it is one standard that is used for all fields, which is that the individual must be able to show that they are one of the small percentage who have risen to the very top of their field of endeavor, such that you have sustained national or international acclaim in your field, and your achievements have been widely recognized in your field of endeavor by your peers and by relevant organizations. All right, so then let's move on and talk a little bit in more detail about each of those categories and how you can qualify for each of those categories. Now let's start with the O-1A visa. So as I mentioned before, the O-1A visa is relevant to individuals who are active in the sciences, education, business, and athletics. And the way to determine eligibility for the O-1A visa is that the beneficiary must show either of the two ways for the evidence. So the first way to qualify is if you have received a major one-time internationally recognized major award, and really they're really looking for the top tier awards like the Nobel Prize, like a household name award that anyone can recognize, or the Pulitzer Prize, for example. The next way, and I would say this is the way that 99% of the cases that I see are going, which is through showing that the individual can produce evidence meeting at least 3 of the following enumerated evidentiary criteria. So let's go through what these mean. So receipt of nationally or internationally recognized prizes or awards. These are actually, they're not talking about the Nobel Prize type completely top of the field awards. So if it is any award that is somewhat nationally recognized, for example, if you were awarded a research award from a university that is a very famous university, maybe you can use that to support that you have received prizes or awards in your field that has a national recognition. So this category is looking for a little bit of a lesser level of awards. The second evidentiary criteria is membership in associations in your field, which require outstanding achievements. And one common example that we talk about is the IEEE fellowship of the engineers. To be elected as a fellow, you need to be invited by someone, and you'd go through a panel expert evaluation of all of your achievements in that particular field of engineering in order to be elected as a fellow. So those kinds of vetting procedures, that's what they're looking for when they're asking, are you a member in a professional association? So by contrast, if you are just a member, let's say I'm a member of the New York State Bar, but that in itself will not really count as membership in an association that requires outstanding ability of its members. And the reason why is because in order to, gain admission to the New York State Bar, you just need to take the bar and pass it. And that doesn't necessarily require outstanding ability in your field as compared to your peers. So that is one way that you need to show a distinguished stature of that particular organization if you want to meet the criteria that is described here. The third one is public material in professional or major trade publications, newspapers, or other major media about you and your work in the field. So really, if you have been interviewed by the media in the newspaper, for example, a nationally distributed newspaper talking about your work, your achievements, you can certainly pull examples of that and submit and meet the criteria here. It doesn't need to be traditional media. It can also be industry publications. So let's say you are an expert in aquaculture, fish farming. And let's say there is a trade publication, a magazine, that is specific to the fish farming industry. And let's say they did a feature on you and your particular approach in fish farming that was innovative to the field or superior in some way. That can certainly also be used to meet the criteria here, published material about you, because it's been published in a major trade publication. And the definition of a trade publication is really based on the intended audience and the content of the publication. And major status, really, you want to show data regarding the circulation of that publication to count as a major publication. It can also be online publications. And there is a way to measure circulation online and measure the monthly traffic. So that's another way we measure the major status of a publication to meet this criteria. So the next criteria that you can use is original, scientific, scholarly, or business-related contributions of major significance in the field. Such as new discoveries in your field that's been published in patents, new discoveries in your field published in academic papers that has been cited, that has been widely cited by other independent experts in your field. It can also be business-related contributions if you are an entrepreneur who is active in the industry. To substantiate that you have made those original contributions, it is important to get third-party evidence of the impact of that work. And also, one thing that can be helpful is to get expert letters who can describe in detail your personal role in making that project possible, who can really develop the narrative of how this achievement was an original contribution in the field, such that it improved upon existing and prevailing approaches. So expert letters can play a very big role in meeting this criteria. Now, authorship of scholarly articles in professional journals or other major media in the field, it is a straightforward criteria here. If you have authored journal articles that have been published in academia, definitely that'll meet the criteria. Other major media, such as I've had clients who've published on TechCrunch, which is a major tech media source online with millions of monthly traffic. That can also be considered as a major media source. So, and the thing about this is that the article must be scholarly. And what does that mean? It means that the article must be intended for a learned audience, right? So it can't be just any article that you post somewhere, right? It can't be a general article talking about a field that anyone, even novices in the field, can read. The definition of a scholarly article here is, something that's been heavily researched, something that's, intended for people who are experts, who are already familiar with the general field that you're writing on. So definitely there are nuances that you should consider when collecting evidence under this criteria. High salary or other remuneration for services as evidenced by contracts or other reliable evidence. Yeah, so high salary is another way you can meet one of these criterias. Important thing is to present the comparison data of how your salary compares to others. And it is important to also note that not only your regular salary, but in cases where if you're a CEO and you receive stock options, that can be, we can present a valuation of that. Those types of other types of remuneration can also be used in addition to your regular wages. Participation in a panel or individually as a judge of the work of others. So a classic example of participating as a judge of the work of others is performing peer review for an academic journal. For individuals who are active in business, one thing you can use is if you have participated in a judging panel for a business competition, a startup pitch competition. If you're asked to judge such competitions, you can certainly use that to meet this criteria. Even in some venture capital firms, you may, if you're a director of a high level in such firms, you may have participated in evaluating, a high volume of different startups and evaluating them for the purpose of awarding investments that can maybe potentially be used, right, as one of the examples towards meeting this criteria. Finally, employment in a critical or essential capacity for organizations and establishments that have a distinguished reputation. Now, let's say you are an entrepreneur, and let's say you have served on a senior capacity, executive capacity, like a CEO, director of engineering, or head of engineering, or COO, or any role that can be considered critical, essential, leading, right? And let's say that organization itself is a distinguished organization, such as, one example that I use is Shell Oil. Shell Oil is a huge corporation. It's been around forever. One of the criteria that the USCIS uses is longevity. How long has the institution been around? What is the renown of the institution? Is it a household name? Is it well known in the industry? Has this organization been mentioned in other, correspondence, media reports, or things like that? So, for example, even if it's a startup, right? Is it a startup that has won prestigious awards? Is it a startup that has been mentioned in, major trade publications like TechCrunch, for offering something that is groundbreaking to the industry? So even if you were CEO of a startup, if you can prove that the startup is an organization with a distinguished reputation, you can potentially use that and collect the evidence that you were employed in a critical or essential capacity. So if you can present evidence under 3 out of these following evidentiary criteria, that is the way that you can qualify for the O-1A visa. And then let's move on and discuss the O-1B visa. So as I mentioned before, the O-1B visa is relevant to individuals who are active in the arts, motion picture, and television industries. So either you must show that you have received a major internationally recognized award in your field, such as an Emmy, a Grammy, a Tony Awards, something like that, or provide evidence under 3 of the following criteria that is listed here. And I'll just quickly go through them. Having been or about to perform a lead or starring role in productions or events that have a distinguished reputation, and it will be expected that you will be able to provide evidence of why it has a distinguished reputation through critical reviews, press releases, media features, and things like that. Critical reviews or other published material about your work or authored by you, which show that you have received national or international recognition or for your achievements in that particular field. Evidence of performance in a lead, starring, or critical role for organizations with a distinguished reputation. I've already mentioned a little bit about that in the context of the O-1A. A similar criteria is here for the O-1B as well. A record of major commercial or critically acclaimed successes in the performing arts, as shown by box office receipts or records, sales figures. So really the objective numeric figures are important here. Evidence of significant recognition for your achievements from organizations, government agencies, or any other recognized expert in your field. So the way you can approach this criteria is to obtain expert letters from leading individuals in the industry who are already known to be high performers. They can provide testimonials describing your work in detail and explaining why your work sets you apart from the majority of other performers in that area. So it is important who you're getting the letter from, in addition to the content of the letter. You want to get them from those who are in senior positions in organizations that are leading in your field, that have a reputation in your field, or government agencies. covering the field, or any other recognized big names in your particular field of endeavor. Finally, a high salary or other significantly high remuneration for services in relation to others in your field. Similarly to the O&A context, you would want to present evidence of your own salary, and also present data that is comparative, the average in your field, to show that comparison there. And you can also use other forms of remuneration than just your formal salary, if applicable in your situation. All right, so now let's move on and compare the O1A and O1B categories. What are the similarities and what are the differences? So the important difference to mention is the fields that are applicable to each visa category. So for the O1A visa, you need to be a professional in the sciences, education, business, or athletics. For the O1B visa, it is relevant to individuals in the arts, the motion picture, or television industry. The standard of extraordinary ability and the definition of extraordinary ability is different. So for the O1A visa, you need to show that you have achieved national or international acclaim, sustained national or international acclaim in your field, such that you can be described as one of the small percentage who have arisen to the very top of your field of endeavor. Now, for the O1B visa, the standard is a little lower. So for the arts, what they're looking for is distinction. It means a high level of achievement as evidenced by a degree or skill and recognition substantially above that ordinarily encountered. So notice that it's not, asking you to be the top 1% of your field, just that you should be able to present evidence that you're operating at a level substantially higher than the average. For the motion picture and television industry, they're looking for a level of recognition and acclaim substantially above your peers. So definitely they are looking for a degree of fame to be expected by someone who has extraordinary ability. Now, the length of the visa is the same for both categories. For the initial visa, you would get 3 years. And with that visa, you can come in and out of the United States and continue to work in your particular project. You can apply for an extension after that if the initial category of projects in the United States that you're doing, if you need an extension for that, you can apply for a 1-year extension. If you have a completely new slate of projects that you're needed in the US for, then you could potentially also apply for a 3-year extension for the O1A and O1B, depending on what projects you are about to participate in for the future. And one thing that I forgot to mention for both the O1A and O1B, you do need a US petitioner. And what does it mean to have a US petitioner? The application must be filed by either your US employer or a US agent, and the agent must be a US person, right? And the work arrangements, if you're using an agent, you must also be able to provide evidence that you actually have work that is lined up, projects in the United States that you are coming in the United States to develop, right? So you can't self-petition for an O1A or O1B like the EB-1A. The EB-1A, you can apply as a foreign individual. However, to use the O1A, O1B visa, you do need a US-based petitioner. One thing that I do want to mention, though, is if you're an entrepreneur, right? And if you set up your own company in the United States, that company, even if you own the company, right, that company can act as the US petitioner and be sort of, the host of all your activities in the United States, right? So that is one strategy that we've seen that can work in the context of entrepreneurs. Now, the final thing to mention is, can family come to the United States? So the answer is yes. Your spouse and your minor children can join you on an O3 visa. And the spouse and children can attend school when they're here. However, The spouses cannot work in the United States on an O3 visa. They do not qualify for work authorization. So that can be a disadvantage in some cases. All right, so now let's move on and discuss the EB-1A green card. So the EB-1A is a green card category for individuals of extraordinary ability, and it is a category where someone can self-petition for a green card, as I mentioned earlier, as opposed to requiring a U.S. employer to act as the petitioner. And it is important to note that the standard of extraordinary ability for this particular green card category is very high. And part of this is because the USCIS engages on what is called a two-step Kazarian analysis, based on the case Kazarian versus USCIS, which not only looks at whether you can submit at least 3 out of the 10 criteria that is listed, but also they look at the quality of the evidence. And they ask whether holistically the evidence taken as a whole, does it paint a picture that you are one of the very small percentage of people who have risen to the very top of your field of endeavor, right? So they look at both the quantity and quality of the evidence in that step 2 Kazarian analysis. So even if you are able to meet technically 3 out of the 10 criteria, that is not enough. Both the volume and the quantity of the evidence will be taken into account at step 2 of the analysis. So, for example, the first step analysis is a technical question: have you submitted any evidence under 3 out of 10 criteria, right? So let's say you have, one media feature in a major newspaper. Let's say you've performed 1 peer review, which counts as a judge of the work of others. And let's say you've worked, in a critical role in 1 organization that can be considered distinguished, right? You would definitely meet the first step analysis because you are able to provide evidence under 3 criteria, as set out in the regulatory language. However, that may not be enough, right? So once you meet the threshold, the USCIS will go on to the second step of the Kazarian analysis and really ask the question, looking at the evidence, the holistic collection of the evidence as a whole, right? Does the evidence, taken together, paint the picture of someone who has truly risen to the top of your field, right? So the quality of the evidence comes into play here. Compare a case where someone was featured on a cover story on a major newspaper magazine like Time, with a photo of the person on the front cover, as opposed to, a newspaper report where your work is only discussed in like 3 lines in a different cover story. The quality of the evidence in those 2 cases are definitely different. So all of these details and nuances will be taken into account at the second step of the analysis. And that is why the EB-1A can be a more challenging category to qualify for the green card under, as opposed to just qualifying for the O-1A or O-1B, even though the regulatory language of extraordinary ability are, presented in very similar language. All right, so to shift gears a little bit now then, let's talk a little bit about one alternative option that you may want to explore, especially if you feel like maybe your credentials are not right up there for the EB-1A. You can maybe consider the EB-2 National Interest Waiver visa category, which is another green card pathway where someone can self-petition for a green card without requiring a U.S. job offer, without requiring a U.S. petitioner, and without requiring the U.S. employer to go through a labor certification petition. The national interest waiver exempts you from that, and you can self-petition for a green card if you meet the criteria. So let's talk a little bit about the eligibility category. So first, the individual must show that they meet the EB-2 threshold requirement, and that is the minimum requirement to qualify under the EB-2 category. So you can meet this in 2 ways. The first way is to show that you have an advanced degree, which is defined as a master's degree or higher, and a PhD degree, for example, would qualify, and a JD or MD degrees like an MBA even, where you are expected to have a bachelor's degree to gain admission to those programs. Those would qualify as advanced degrees. Now, you can also meet the advanced degree criteria if you have a bachelor's degree in your field. and 5 or more years of progressive work experience after you have earned your bachelor's. So what does progressive work experience mean? Progressive work experience means your duties in your particular position has changed over time with increasing complexity and increasing seniority, right? So if you're in the same position for 5 years, that's not going to count as progressive work experience, only if you have been increasingly progressing in your career to a higher level. That can count as the 5-year progressive work experience that you need to have, that you need to show to combine with your bachelor's degree to show that you have the equivalent of an advanced degree, a master's or higher. Now, if you don't have that, right, there is still another way you can qualify under the EB-2 category, and that is by showing that you have exceptional ability in the sciences, arts, or business. And the way to show exceptional ability is very different from extraordinary ability. Right off the bat, we can see that the criteria for exceptional ability is much lower than the criteria for extraordinary ability. So you must show that you meet 3 out of the 7 criteria that is listed here. One thing, for example, is 10 years of full-time experience in your field. Another criteria is high salary compared to other people who are active in your field, and evidence of recognition for your original achievements by peers, industry, government actors. You can see that there is some similarity with the criteria that is relevant for the O1A, O1B, EB-1A, but definitely what they're looking for exceptional ability is a much lower standard, such that you can qualify if you can show that you have a degree of expertise that is significantly above ordinarily encountered in the field. So even from that language, you can see that you don't need to be at the very, very top of your field to qualify as someone who has exceptional ability. Now, once you can show that you've met the EB-2 criteria, the next step is to show that you actually qualify for the National Interest Waiver Green Card. And the National Interest Waiver Green Card is adjudicated in a 3-pronged test that is promulgated by a case called Matter of Denisar, right? So the first criteria that you need to meet is that your proposed endeavor in the United States have substantial merit and national importance. And what does that mean? So substantial merit can be proven in a wide variety of fields, including business, health, education, science, technology, and endeavors that further human knowledge in those key areas, such as medical advances, improvements in civil engineering practices, can qualify as endeavors with substantial merit. Now, for national importance, what the government is looking for is what is the potential impact of your work to your field? Does your work stand to just benefit your immediate employers or clients, or does your work somehow advance the way things are done in your field, such that you can improve best practices, improve technology, improve U.S. competitiveness in a particular area that is significant for national interest? And another argument you can make is show that your work stands to make a strong economic impact in the United States. So the question to ask is, what is the potential impact of your work in the United States, and why is that important, right? And you can bolster this argument by pulling government reports showing that certain areas are priority for the U.S. government, such as environmental sustainability. That's where you've seen a lot of executive orders come in, a lot of investment by the federal government in sustainability technologies like electric vehicles and things like that. Veterans welfare, that is another area where you can see a lot of promulgations by the U.S. government showing how it is important to foster better infrastructure, better social infrastructure for veterans to be integrated into U.S. society. So third-party reports, government reports, expert letters describing those gaps in the programming, and then linking that to your particular project and what you can do to improve the state of the land in those industries. That is the key to the national importance argument. Now, once you have done that, the second criteria is that you need to show that you yourself are well positioned to advance the endeavor. And you can show this through showing that you have education, you have experience, and that you have a record of success in similar and previous related projects. And having a volume of evidence supporting this is important to support the argument that that your work cannot really be replaced by someone else with minimum credentials. You have unique knowledge, you have the unique know-how that really positions you the best to create this strong impact to the United States technology, United States competitiveness, any interest in the United States. So the third prong to meet is that on balance, it would be beneficial to the United States to exempt you from the ordinary requirements of labor certification. And that argument is made a variety of different ways. You can rely on the first prong and talk about the broad systemic benefits your work can have to the United States as a whole. You can also rely on the second prong, talk about your unique skills and experiences that cannot easily be replicated by another US worker. You can also talk about some special considerations, especially if you are an entrepreneur. You can talk about substantial economic benefit to the United States that can result from your business endeavor, such as job creation and generation of tax revenues. We do have full webinars, by the way, on the national interest waiver and how to qualify for that. You can check us out on the YouTube channel or attend any of the upcoming webinars on the NIW, and we will go into much more detail on how to qualify for the EB-2 NIW visa. All right, then now let's shift gears and move on and talk a little bit about expert opinion letters, which plays an important role in the O-1, EB-1A, and NIW petitions. Now, for certain type of petitions, such as the NIW, what the expert letters do is that the letters can either confirm the national importance of your proposed endeavor, and letters from a government agency official can really help with that. Another type of letters for the NIW can talk about the applicant's contributions to their field, a past record of success in the field of endeavor, right? Another function of the expert letter in the context of extraordinary ability petitions, such as the O-1 and EB-1A, is really explaining what you have done to the field that is outstanding, right? So those letters will really go into detail about your most salient achievements in the field, your critical roles in leading institutions, distinguished organizations, and your substantial contributions original contributions to the industry. All of those elements can be really brought up by the expert letters, and together with the other forms of objective third-party evidence, the expert letters really play a big role in building the narrative of why you are someone who is outstanding in the field and can be very important for the success of your case. Who is writing the letter? So you really want to get letters from experts in the field who are objectively can be considered leading experts, right? So usually what we would do is also append the full-length CV of the experts with the letter. And typically there will be many pages of, accolades, publications. Those experts would typically have even more impressive credentials than the applicant themselves. So that is kind of the idea that you should have when you're looking for experts to support you. In the NIW context, because the category talks a lot about national importance, it is very helpful if you can get a letter from a government official. For example, if you're a scientist and you're doing some high-tech research, can you get a letter of support from someone who is at NASA? That can really bring a leg up to your case, right? For the NIW context in particular, because they're really looking for the national impact and, on balance, how does it benefit the United States? And a government agency letter can really show the support for that. How does the individual know you? So it is recommended to have a mix of independent letters and inner circle experts. Independent experts are people who you have not directly worked with you in the past, but they do know you through your leading contributions in the field. And those can be objective forms of evidence of your prestige and renown in your particular field. Inner circle experts are people who have worked with you. And because they have worked with you, they can provide a more detailed testimonial of what your personal roles were in a particular project and why is it important to the field. Now, what is the content of those letters? So it is important to include a discussion of your work, recognition, accomplishment, and achievements through specific examples. And it is very important to develop those specific mini case studies. If the letter is just filled with flowery language, very abstract, conclusions that, oh, this person is extraordinary, period, then that's not going to be very persuasive, right? Because USCIS officers are told not to rely on conclusory or general statements. So the content of these letters is good if they can be as specific as possible with regards to your contributions and why it was important and what was the real world impact of your work in your field. All right, so the next topic that we can discuss is what category should I apply for? What are some of the strategic considerations when you're choosing between these different categories that are available for extraordinary ability individuals? So one question is, do you want to stay in the United States temporarily or permanently? So the O-1A and O-1B are non-immigrant visas. They are well suited if your intent in working in the United States is temporary. And if you maintain strong ties to your home country and you need to travel in and out frequently, and maybe you want to stay in your home country for long periods of time. In that case, the O-1A and O-1B could give you that perfect balance of having this connection to the United States, but also keeping a strong connection to your home country. Now, the EB-1A and NIW are green card categories, and they are really well suited for people who want to live in the US permanently. And also, once you get the green card after 5 years of living in the United States, you can potentially also apply for citizenship. So if those are things that you want to build towards in the future, the EB-1A and NIW are definitely the categories you should look at. The other question is, do you have a US employer or agent who can serve as the petitioner, or do you want to self-petition? As I mentioned before in previous slides, both the O-1A and O-1B visa categories do require a US employer or agent to lead the petition. The US agent must be a US person, and the US employer, it can be a company that you own. However, it must be a US entity. It cannot be a foreign entity. Now, for the EB-1A and NIW, for both of these green card categories, you are allowed to self-petition as an individual beneficiary. So that can be advantageous if you do not have those ties to the United States. Family considerations. One thing to note is that for the O-1A and O-1B visa, your spouse and children under 21 can join you and come to the United States as O3 dependents. And if you do that, your spouse and children are allowed to study in the United States. But your spouse cannot work because the O3 visa does not provide work authorization. Now, by contrast, the EB-1A and NIW are both green card categories, and your spouse and children under 21 can apply for green cards with you. And if you are applying for the green card with the adjustment of status approach, which is you're already in the United States and you're filing an I-485 to adjust status to a green card holder, you qualify for applying and getting a work authorization, an EAD, an employment authorization card that allows you to work for any employer. And when your spouse also applies for that, they get the same benefit. Travel authorization, it is relevant if you have filed your I-485, but you want to get the ability to travel in and out of the United States while your green card application is pending. Your spouse can get the same benefit as well. So that can definitely be one of the advantages that you consider. All right, considerations when moving from a non-immigrant visa to a green card. So it is important to go through this because there are a couple of risk factors that you need to consider. So the first issue is qualifications. So as I mentioned in the previous slides, the EB-1A is a category that is looked at with much scrutiny. So even though the regulatory language is very similar, they talk about extraordinary ability, because of the Kazarian two-part test, the USCIS looks at EB-1A petitions with a very strict eye. They're really looking for those who have reached the very, very top of their fields. So it is true that qualifying for the O-1A or O-1B does not mean that you would automatically qualify for the EB-1A. So there is a little bit of a difference in the standards that is required to be approved for each category. Timing is also an issue. So if you already have a non-immigrant visa, right? One of the things that the government looks at when you're renewing or applying for a new non-immigrant visa is, do you have non-immigrant intent? right? And if you file a national interest waiver petition on the EB-2, or if you file EB-1A I-140 petition, those can be seen as expressions of immigrant intent. So once you apply for those green card categories, the next time you apply for a non-immigrant visa category, you could get a more challenging, you could have a more challenging time describing non-immigrant intent, since the action of you applying for the NIW or applying for the EB-1A can be taken in some way to be an expression that you intend to immigrate in the future. Now, there are strategies to work around this, and this is more of a problem for some visa categories as opposed to others. So definitely talk to your lawyer to understand the nuances of these risks. However, definitely in some cases, it could be a better approach to extend or renew the visa first and then work on your green card application. Finally, considerations regarding family. If you have family members who also need the green card, especially for children, they age out at 21. It could be good for you to expedite your green card application if you anticipate your children aging out in the near future. So finally, the final topic that we would cover before closing is, are extraordinary ability categories available for entrepreneurs? And the answer really is yes, right? And as we covered this topic extensively in previous slides, the EB-1A and NIW are green card options where self-petitioning is possible. You do not need a U.S. job offer. You do not need a U.S. sponsor to qualify for those green cards. This means they are both very viable and possible options for entrepreneurs. Now, regarding the national interest waiver option, there has been changes in the NIW standard under the new matter of DANISR prevailing case law, which made NIW a much more friendlier category for entrepreneurs. And there are a lot of strategies you can explore on that. Definitely check out our separate webinars on the NIW if you'd like to learn more about that. And finally, one thing to mention here is that it is possible to apply for an O-1A if you're an entrepreneur, as long as you have a separate corporate entity in the United States that can act as the petitioner. And it is okay if you have ownership of that U.S. entity, but you do need to have that legal U.S. entity that can act as a petitioner. All right, so that is all that I have for you guys today. If you have any questions, definitely send them now. And I'll give a couple seconds to see if anyone has any questions. Doesn't seem like it. So then I will close here. Thank you everyone for your participation. Keep an eye out for the resources that we will be sending to everyone. And if you would like to discuss your case further with any of our experienced attorneys, please feel free to reach out to us by clicking on the consultation link. We look forward to hearing from you. Have a great day, everyone.